Welcome to Europe Explained, brought to you by the Council of Europe. This podcast series offers a unique window into what we're doing to create a fairer, more democratic Europe. Through conversations with experts and frontline workers, we bring you closer to the issues that matter, from fighting discrimination to upholding human rights, from defending democracy to building laws, systems and institutions that are just, fair and open to all.
Welcome to this new episode of Europe Explained, the Council of Europe's podcast that highlights the work of the Council on human rights, democracy and the rule of law. In today's episode, we're going to focus on persons deprived of their liberty in psychiatric institutions. We've already released several episodes exploring the CPT's work, so if you'd like to learn more about it, please listen to them. Today, we're turning our attention to the CPT's work in psychiatric establishments, and to explore this topic, I'm joined by three experts. Peter Hnatic, you're a lawyer. You've worked for the CPT for the last 15 years and previously as a lawyer at the European Court of Human Rights. Alexander Tomsuk, you're a psychiatrist. And Karine Rouhani, a lawyer. Can we please start by describing these different types of psychiatric institutions? Peter.
Yes, there are basically two main types of establishments which we are visiting, and always the main precondition is that they accommodate persons deprived of their liberty. These are the limits of the CPT's mandate. So the first type of establishment would be so-called civil psychiatric hospitals, and these are establishments which, in addition to voluntary patients, meaning patients who arrived voluntarily, they are free to leave, they're free to go home. In addition to these voluntary patients, they also accommodate involuntary patients who have been placed in these establishments by a civil court, meaning in a decision issued in civil proceedings. So that's the first type of establishment, civil psychiatric hospitals. The other type of establishment that we are visiting are so-called forensic psychiatric hospitals or forensic psychiatric facilities. And the placement in these facilities has been ordered in the criminal context, so by a criminal court. And for example, they accommodate persons who are undergoing a forensic psychiatric assessment to establish their criminal liability, whether they are criminally liable for the act they have committed, or these are people who have already been declared by a criminal court or in the context of criminal proceedings. They have been declared criminally responsible for their act by a court and have been placed in a psychiatric establishment in replacement of a prison sentence. So that's the second type of establishment. There is a third type of establishment which it doesn't exist in all countries, but in some countries this exists as a separate establishment or a separate type of establishment or a separate type of a criminal measure, if you want. And they have different names in different states. That they may be called preventive detention, security detention, or a secure forensic placement. And they are usually intended for persons, for patients who have been declared criminally irresponsible for the act they have committed, but are considered too dangerous to be accommodated with other forensic patients in an ordinary forensic ward, in a forensic ward of an ordinary hospital. So by their nature, these establishments are close to forensic psychiatric hospitals, but in some countries they exist as a separate concept. I think in this context, it's also important to mention that we visit both public and private institutions, and it is not relevant for our mandate whether deprivation of liberty is based on a formal decision or not. We often meet patients whose circumstances amount to a de facto deprivation of liberty. Now, what do I mean when I talk about a de facto deprivation of liberty? These are patients who are formally regarded as voluntary, but in practice are not free to leave the establishment. For example, these persons initially arrived voluntarily, but later when they try to leave the establishment, they're not allowed by staff to do so, or the consent to their admission was signed by a relative or their guardian, and later they are not free to leave the establishment. And This category of patient is of a particular concern to us because their involuntary stay in the establishments is not accompanied by the legal safeguards which would normally accompany involuntary placement.
And so what would under what legal grounds, Alexander, can someone be involuntarily admitted to a psychiatric hospital? I was saying you're a psychiatrist. You're also an external member of the MPM and a member of the CPT from Montenegro. What's your experience?
So actually, according to the standards of the involuntary admission to a psychiatric hospital must be strictly regulated and justified. The CPT and NPM also repeatedly stresses the deprivation of liberty for psychiatric reasons must only occur under clear legal grounds and with strong safeguards. So the first essential condition is that person must be reliably shown to be suffering from a genuine mental disorder. The diagnosis should normally be made by a qualified psychiatrist, and the mental disorder must be a nature or degree that justifies compulsory confinement. The CPT often refers to the jurisprudence of the European Court of Human Rights, which established that a mental disorder must be objectively established by medical expertise. Even if a mental disorder exists, involuntary admission is only justified if hospitalization is necessary. So legal grounds include situations where the person represents a danger to themselves, for example, a risk of suicide or serious self-harm, represents a danger to others, when the person is unable to care for themselves due to the severity of the mental disorder, and requires treatment that cannot be provided in a less restrictive settings. So it is important to know that even the same diagnosis sometimes can be treated outside from the hospital. So the CPT emphasized that hospitalization should be a last resort. The decision should be based always on independent medical assessment. Usually at least one psychiatrist must confirm the need for involuntary admission, and in many systems 2 independent medical opinions are recommended for a stronger safeguards. Also, the CPT insists that involuntary admission must be subject to legal control. So key safeguards include a formal legal decision made by judicial or administrative authority, prompt review by a court or independent body, right of the patient to appeal the decision, and periodic review of the need for continued detention. Also, a person who is admitted involuntarily should be informed of the reasons for their admission, have access to legal assistance, be able to contact relatives or a lawyer, and have the right to challenge the placement before a court. So, according to our standards, a person cannot remain involuntarily detained once the mental disorder no longer justifies hospitalization. So, in a situation when the patient is recovered or is in a better stage, there is no reason for continuing involuntary admission. And of course, we also insist that there must be regular medical reassessments.
And talking about the standards, Karen, I'm turning to you now. You're a lawyer. You're also a trained social worker, an expert in health ethics. What are the CPT standards during your visits? What specific issues or conditions do you pay particular attention to?
Thank you, Laura, for this question.
A big question, I know.
It's a big question, yes, and I will try to answer it clearly. Yeah, over the last 3 decades, the CPT has worked now for 35 years already. We have developed comprehensive standards to protect people deprived of their liberty, and they are firmly based on Article 3 of the European Convention of Human Rights, as we already mentioned in the other episodes. And Article 3 absolutely prohibits torture and inhuman or degrading treatment. And this is a principle which guidelines all our work. So anyone deprived of liberty must be treated with dignity and respect. including psychiatric patients. So a key requirement, therefore, is a proper therapeutic environment, sufficient qualified staff, and adequate medical care. Against the background of Article 3, we focus on how these standards implemented in the practice when we visit an institution. So first of all, of course, we look if there is ill treatment. Luckily, deliberate abuse is rare, even in understaffed institutions, but degrading treatment does occur. So what does that mean? We saw that patients have been slapped, forced into cold showers, or verbally abused, shouted at, which is really degrading. Such cases are more often linked to auxiliary staff. That is why, on the one hand, it is very important that there is enough trained staff, and on the other hand, that this trained staff supervises auxiliary staff, and also that proper training is there also for auxiliary staff. People are very fragile upon admission, and moving into a psychiatric institution can be traumatic. So sharing rooms with other people you don't know is difficult, and very often the institutions are very restrictive, meaning that you are not allowed to wear your own clothes, that you have, for example, to wear pajamas, that you are restricted in movement. You cannot leave and go out to the garden if you feel like it. And you are often also restricted with personal belongings, meaning you can't have pictures of your families, and you cannot take things along which you would really need or like. In some state-run institutions, we even have found basic necessities lacking. There was no adequate food, for example, no healthy food, not enough heating. So it was really freezing cold in winters, or the opposite in summer, very, very hot rooms. And also not proper healthcare. This is also a big problem. Then another thing which we sometimes face is severe overcrowding. In my last visit, I entered a room and I saw 18 people, but just 9 beds. So meaning people had to share beds. We also observed patients being kept in pajamas. I said that already, but this undermines their autonomy. You behave different if you have your favorite
it's
shirt.
Highly symbolic.
Yes,
Yeah.
absolutely. Yeah. And also it is important for involuntary patients that they can go out to get some fresh air. And then we closely examine the use of restraints, but I think Petter will come to that. And we look at staffing and therapeutic care, like are there enough qualified professionals, a wide range of professionals. We have Sasha here as a psychiatric doctor, but there also must be trained nurses, psychologists, social workers, so that the patients have individual treatment and also individual treatment plans. And finally, it is very important for them that safeguards are there. So people must be informed of their rights, have access to complaints, as Sasha already said, as far as possible, be involved in decisions about their treatment so that they know which medication they are getting, that doctors and nurses talk to them about how long shall they be here, what is the goal of the treatment. And also respect for autonomy is central.
But autonomy is a big question. You were mentioning letting people go out when they would like some fresh air, but how do we balance patient autonomy with the need for care and obviously safety for the whole institution, Alexander? That's a difficult question, I imagine.
Yes, it is. And CPT places a strong emphasis on respecting the autonomy and dignity of psychiatric patients, while also recognizing that care and safety sometimes require restrictions. Its approach is based on human rights standards, proportionality, and medical ethics. There are few principles CPT uses to balance patient autonomy with care and safety. In terms of autonomy and informed consent, as the starting point, CPT expects or I would say insist that each patient should receive a clear information about their diagnosis, treatment option, and rights. Treatment should normally be based on free and informed consent, and patients should be able to participate in decisions about their treatment plan. Refusal of treatment must be respected whenever possible. But CPT stresses that involuntary treatment should never be a routine and must be clearly justified, as I already explained before. So this second principle is related with strict safeguards for involuntary placement and treatment in situations when autonomy cannot be fully respected. For example, in severe psychosis or risk of harm, and CPT in that case accepts involuntary hospitalization or treatment, but only under strict conditions. I explained these safeguards before regarding involuntary treatment, but the third important principle occurs least restrictive environment, and this is a central CPT principle, and this actually means that a restriction on liberty must be necessary and proportionate. Patients should be treated in the most open environment compatible with safety, and locked wards, seclusion, or restraint should be used only as a last resort. Strict regulation of use of coercive measures, such as mechanical restraint, seclusion, or forced medication, are particularly scrutinized by CPT. The CPT requires use only as a last resort to prevent immediate harm, shortest possible duration, when we are talking about minutes rather than hours, continuous monitoring by staff, detailed documentation in register about applying this kind of measures, and the constant medical supervision. CPT repeatedly states that coercive measures must never be used as a punishment or for staff convenience. The next principle is related with therapeutic engagement instead of pure control. To protect autonomy while maintaining safety, CPT encourages individualized treatment plans, psychological and social support, regular contact with staff, and activities and rehabilitation program. Last important principle is connected with complaints and external oversight. In that term, to protect patient autonomy, CPT stresses the importance of accessible complaint mechanism, confidential contact with lawyers, family and oversight bodies, and independent monitoring of psychiatric institutions. These safeguards reduce the risk of abuse or excessive restrictions.
One of the big CPT monitoring works is on prisons, where another place where people are deprived of their liberty. These establishments are very different, but do your standards in some way look a little bit like the ones the CPT has for prisons, Peter?
Before I turn to our standards, I will start with our monitoring methodology, and that is very similar in the different types of establishments that we are visiting. At the beginning of each visit to a particular establishment, we meet with the management and staff. We have some initial talks with them, some initial exchanges. We also examine various records. These records depend on the type of establishment that we are visiting, but then most of the time we spend interviewing in private persons deprived of their liberty. And I insist on in private because to get their stories, how they are treated in the establishment or how they have been treated in the past, for example, by the police, we need to talk to them in private without the staff around us. Turning now to our standards, I think some of the very basic standards will be generally applicable and will apply in all places of deprivation of liberty. I think Karin already mentioned the absolute prohibition of torture that will apply in all the places we are visiting, the need to effectively investigate allegations of ill treatment, or, for example, certain minimum standards concerning the state of repair of these facilities. So these would be the very basic standards that apply everywhere. However, many standards that we have developed and that we apply in the different establishments that we are visiting are very specific. They are really specific for the particular type of establishment, and standards that apply in prisons or that have been developed for prisons cannot automatically be applied in police establishments, immigration detention facilities, and in particular not in psychiatric hospitals, in psychiatric settings. Each type of the establishment is very specific and requires a different approach and different standards that should apply. For example, when it comes to material conditions, one of the basic issues we look at during our visits, they should be very different in prisons and in psychiatric hospitals. To put it very simply, prisons should look different than psychiatric hospitals. In psychiatric hospitals, there should be something we call a positive therapeutic environment. So these premises should be conducive to the treatment and well-being of patients and their psychosocial rehabilitation. And as Karin already mentioned, patients should be allowed to keep certain personal belongings. They should have lockable storage spaces, and the patient's rooms and all the premises should be pleasantly decorated. As opposed to that, prisons will be, by their nature, very carceral. What we often see in prisons is an austere environment. So this should be very different in psychiatric settings. Leaving aside now material conditions, also the daily regime will look very differently in a psychiatric hospital than in prison. There are specific standards in psychiatric hospitals which concern medical treatment of patients and, as Sasha already mentioned, for example, the use of means of restraint. These will be very specific for psychiatric hospitals and will not apply automatically in prisons.
Of course. And you've mentioned a lot of issues that are a matter of concern during your visits. Karin, are there any other issues that arise in your different reports? I expect it's very different from a country to another, but...
Yes, it is. We have 46 different countries, and it is a bit tricky to find recommendations which are applicable to like Iceland and also like Azerbaijan and to Austria and to Switzerland. But, psychiatric institutions are normally a part of the healthcare system and are meant to provide proper healthcare to patients in all the countries. So there should be no difference where the patients are situated. But what we see really in all the countries, that institutions are open to mistreatment, excessive restraint, degrading conditions, or neglect of dignity and autonomy, because behind closed door, human rights violation can occur. So here in psychiatric clinics, we have patients who are often highly vulnerable, especially during involuntary hospitalization. So they did not choose to go to the hospital, but they were brought in. So their freedom is restricted, and they depend entirely on staff. So this is where the CPD and other monitoring bodies come in, because without independent monitoring, abuse remain hidden in these institutions. And this is one of our recommendations, that there should be an independent monitoring body. Across different countries, we see recurring concerns. One is the excessive or prolonged use of coercive measures. I think Petter will come to that a bit later. Another is the lack of safeguards during involuntary hospitalization, like Sasha already meant. So we very often see that we carry out interviews with the patients. So we go to the patient's room or take a little walk with them. And then we ask them, do you know which medication you are getting? Do you know what your rights are? And we see there is very often a lack of access also to legal remedies. Then understaffing is a very huge problem we see. In one of my last visits, there were in one institution almost 500 patients. And guess how many psychiatrists were there?
2?
3? Free psychiatrists for 500 patients, meaning 170 patients per psychiatrist, and also just 4 trained nurses. So you see, this interdisciplinary approach Petter mentioned is really hard to carry out if you have such a lack of staff. It's even very hard to proper intervene and to proper take care of the individual person there.
And also one of the recurring concerns, you've mentioned treatment at the beginning of this episode, but relates to treatment. What types of treatment practices do you most commonly observe? And especially as a psychiatrist, what are your recommendations, Alexander?
So actually regarding the treatment, the CPT emphasized that psychiatric patients must be treated in accordance with the human dignity and respect, least restrictive environment, therapeutic purpose rather than custodial control, and the treatment needs to be individualized. That means that for each patient, according to our standards, each patient should have an individualized treatment plan. Plans should include psychiatric diagnosis, treatment objectives, medication strategy, psychosocial interventions, and rehabilitation measures. Unfortunately, in many countries we are visiting, we find out that the treatment is based mostly exclusively on pharmacotherapy, which is really not acceptable, and it's not a part of the complete treatment. Hospital must ensure access to psychotherapy, occupational therapy, social rehabilitation, educational activities, and physical exercise. Regarding treatment, we are also pay attention on therapeutic environment, and we always request that psychiatric institution must provide adequate living conditions, access to outdoor exercise every day, and meaningful activities. Patients should not spend most of their day locked in their rooms. The CPT always criticize systems where the wards function like detention facilities and where is a lack of therapeutic engagement. The other point is related with the staff and the multidisciplinary approach, and we always require a multidisciplinary team, typically including psychiatrists, psychologists, nurses trained in psychiatry, occupational therapists, and social workers. Adequate staff leveling are essential to provide therapeutic activities, to prevent violence, and reduce reliance on coercive measures. And of course, patients should sign informed consent, and I mentioned it before, and have a clear information about their diagnosis, treatment options, medication effects, and side effects.
And you were mentioning the vulnerable groups. Who are these people that require special attention when you conduct these visits? Is it women, children, or?
Thank you for this question. It's a very important question. There's certain groups who face a higher risk due to personal or social or health circumstances. They need special attention because they could face neglect, stigmatization, or discrimination. These include, like you already mentioned, some groups, but people in acute mental health crisis, particularly involuntary patients, then children and juveniles, Then also people with intellectual or other disabilities. For example, we found in one institution a paraplegic person who had to change his diapers in his own bed without help of anyone, or a blind person who did not get a blind stick, for example. So he was also dependent on other patients. Then we have people with migration or refugee experience who may especially vulnerable to trauma, language barriers, and social inclusions. Then LGBTQI+ persons, and also because of their high risk of violence experience in their history, also women. So these groups require heightened awareness and specific safeguards to ensure the rights and dignity are fully protected.
And you were mentioning restraint practices. What's the CPT's position on the use of restraints? I mean, how do you ensure that they're not disproportionately used Peter?
Yeah, we've already mentioned means of restraint several times. So before I get to the standards, I just want to explain that when we say means of restraint, we usually mean manual control of patients, mechanical restraint, which is usually fixation to a bed with belts, chemical restraint, which is the forcible administration of medication for the purpose of controlling patients' behavior, and seclusion, which is the involuntary placement of a patient alone in a locked room. So this would be, in brief, the use of means of restraint we usually see that are usually used in psychiatric settings. And the use of these measures may be very intrusive, of course, and they have a great potential for abuse and ill treatment. And this is why during our visits to psychiatric establishments, we pay particular attention to these issues, and we systematically assess the practices. We systematically assess how restraint is used, how means of restraint are applied and used. And as a consequence, we have developed a considerable number of standards which should apply in this context. And I think some of them, the really key principles, they have already been mentioned by Sasha when he talked about autonomy of patients. And that is the use of restraint as a measure of last resort and for the shortest possible time. What does it mean? That means that restraint should only be used when it is absolutely necessary. And this will require that, first of all, there's enough staff to use alternative measures, and that staff are trained in the use of alternative measures, such as the de-escalation techniques, oral persuasion of patients, or calming down of patients. The method chosen of controlling a patient should be the most proportionate to the circumstances. What does it mean? For example, when mechanical or chemical restraint should not be used if a brief period of manual control and calming down the patient concerned would be sufficient. Unfortunately, during our visits, we still find devices which are totally inappropriate as means of restraint in psychiatric settings, such as metal handcuffs and ankle cuffs, or even metal chains and padlocks to restrain psychiatric patients, or cage beds. And we've said many times that when it is necessary as a measure of last resort to use mechanical restraint, only professionally recognized means should be used. So, for example, it is acceptable in certain circumstances to use padded soft straps to decrease the risk for the patient, but certainly not metal chains and padlocks. I think this would be, in brief, the main standards. There are many more. As I said it earlier, there's a huge potential for abuse.
Well, before we end this episode, I just have a last question for the three of you. Over the years, you've all worked for the CPT for quite some time. So do you feel that your visits have had a measurable impact, that your reports have made a difference and have been heard? Alexander, maybe you want to start?
Yeah. From my experience, I'm 6 years in the CPT, and reading the report, I may say that there is, of course, improvement in the countries we are visiting, but also I would say it depends from country to country.
It's hard to have a general answer.
They are really looking forward for our recommendation, and they are trying to improve the situation. But unfortunately, there are countries where we repeat the same recommendations from visit to visit. So there is some positive impact, more or less yet. Depends on countries.
And how do you feel about this question?
Let me say, I'm an optimist. I think it makes a difference, even when we go to the institutions and talk to the people,
They must feel heard and seen.
Yes, absolutely. That's it, You talk to a person, you get into a conversation, and that they get the feeling they are not forgotten. And also the institutions themselves sometimes feel supported by us because they want to treat the patients well. They are just sometimes have circumstances where they cannot do better. And so they sometimes really see us as support, because we also can talk to the government and address also their needs to a different stage So I think it really makes a difference that we go to the people, speak to the people, hear the people, and also transfer the messages.
And for you, Peter?
I will try to remain positive as Karin. I think just to say that it is, of course, very rewarding for us to see if there is improvement and if our work has impact. And when we visit an establishment, it often happens that we go back to that establishment to see and assess whether and to what extent our recommendations have been implemented, whether material conditions have improved, whether the overall approach to restraint of patients has changed, etc., etc. We often recommend that legislation should be amended to accompany involuntary placement with legal safeguards. I think more generally and this is linked with the impact of our work, the standards we've been discussing and that the CPT has developed over the years of our existence, they are often used by the European Court of Human Rights when they decide cases concerning persons deprived of their liberty. And I believe this is part of our impact. So not only our findings from our visits, but also the general standards that we have developed are used by this judicial body. And they are also used by our colleagues from the Council of Europe who work on...
Which is a very positive sign.
Absolutely.
Yeah.
And they are also used by our colleagues who work on cooperation projects. It often happens that cooperation projects are based or designed around our findings. So when we identify a shortcoming that needs to be improved, then the Council of Europe comes with a cooperation project, which can be simply improving material conditions, the physical infrastructure, help with legal amendments, but also, for example, training of staff.
Well, thank you for coming and sharing your work at the CPT and this episode. Thank you.
Thank you very much.
Thank you.
If you enjoyed this discussion and wish to explore more topics, be sure to check out the episodes of Europe Explained. You can learn more about the Council of Europe and its initiatives at our website, coe.int. And don't forget to follow us on social media for the latest updates and insights. You can find us on X, LinkedIn, Facebook, and Instagram.